December 9th, 1946. The Palace of Justice, Nuremberg, Germany. 23 defendants sit in 2 rows facing an American military tribunal. They're not soldiers. They're not camp guards. They wear dark civilian suits, clean-shaven faces, reading glasses. One defendant was Hitler's personal physician. Another chaired a university medical school. A third published papers in leading scientific journals. Today, prosecutors will present evidence that these men, along with thousands of their colleagues, systematically sterilized more than 350,000 German citizens against their will. Not in secret, not in hidden chambers, in hospitals and clinics, with signed court orders, medical certificates, and official government stamps. Here's what makes this different from every other Nazi atrocity you've heard about. These sterilizations were legal, approved by courts, performed by licensed doctors, documented in triplicate. The defendants had law on their side, they had judicial precedent, they had medical protocols, they followed proper bureaucratic procedures every single time. The prosecutors know this. The defense attorneys are already preparing arguments about legality, state authority, medical judgment. Everyone in that courtroom understands that proving a crime happened is easy. Proving that following the law can be criminal, that's hard. So the question isn't whether these doctors obeyed German law. The evidence will show they did. The question is, what happens when prosecutors lay 350,000 individual case files on a table and force judges to see what legal really meant? By the end of this documentary, you'll understand how a single law passed in 1933 created a factory line system that sterilized more people than lived in entire German cities. How courts processed 80,000 cases a year with assembly line efficiency. How doctors turned diagnosis into death sentence. How paperwork, not brutality, became the weapon. And how American prosecutors used that same paperwork to dismantle every legal defense the doctors offered. Because the Nazis didn't hide this program. They celebrated it, they published statistics. They trained doctors across Germany in proper procedure. They created a paper trail so complete that 15 years later it walked into a Nuremberg courtroom and destroyed them. If you want to understand how law, medicine, and bureaucracy can combine to create systematic violation on a scale most people can't imagine, and how the Nuremberg tribunals established that I followed the law is not a defense when the law itself is monstrous, stay with me. We're going deep into court transcripts, medical records, survivor testimony, and the moment when judges had to answer a question that still matters today. Can you be a war criminal if you never fired a shot, never guarded a camp, never killed anyone with your own hands, but signed forms that destroyed hundreds of thousands of lives? Before we start, a quick request. This video required weeks of research through primary source documents, tribunal transcripts, and historical archives to give you the most accurate account possible. If this kind of deep dive historical analysis using actual evidence interests you, please hit subscribe. It tells me you want more content like this. And as we go through this story, I want to hear from you in the comments. Where's the line between medical judgment and medical tyranny? When does following orders become participating in crimes? I read every comment. Drop your thoughts below. All right, let's go back to where this started. Not in 1946, when prosecutors opened their files. Not even in 1933, when the law was passed. We need to go back to July 14th, 1933, 6 months after Hitler takes power. The German cabinet meets in Berlin and passes a law with a bureaucratic title, The Law for the Prevention of Genetically Diseased Offspring. There are 14 pages, dry legal language. It sounds like health policy. It reads like medical regulation. And what it actually does is give the state the power to sterilize any German citizen a court deems genetically inferior. The law lists 9 conditions that qualify someone for forced sterilization. Congenital mental deficiency, schizophrenia, manic depression, hereditary epilepsy, hereditary blindness, hereditary deafness, severe physical deformity, hereditary alcoholism, Huntington's chorea. Read that list carefully. Half of those conditions aren't even hereditary. Several can't be diagnosed objectively. A few are so vaguely defined that almost any doctor could justify applying them. That vagueness isn't an accident, it's the point. Because the law isn't really about genetics, it's about control, about deciding who gets to reproduce and who the state deems unworthy. But here's the genius of how they designed it. The law doesn't give doctors the power to sterilize. It requires a court order. Every sterilization has to go through a judicial process. Applications, medical evaluations, hearings, opportunities to appeal. On paper, it looks like due process. It looks like the system has safeguards. In practice, it's a rubber stamp factory. Let me show you how it actually worked. The law creates a new type of court. Hereditary health courts, Erbgesundheitsgerichte in German. Over 200 of these courts are established across Germany within the first year. Each court has 3 members, 1 judge from the local district court, and 2 physicians. One physician is a public health official, usually a Nazi Party member. The other is a specialist in hereditary diseases, meaning a doctor trained in eugenics. Notice what's missing from that panel: defense attorneys, patient advocates, anyone representing the person being evaluated. Here's how a case reaches the court. A doctor, a hospital director, even a social worker can file an application claiming someone meets the criteria for sterilization. The application goes to the hereditary health court. The court summons the person for evaluation. The two doctors on the panel examine them, review their medical history, and make a recommendation. The judge reviews the medical opinion and issues a ruling. If the ruling orders sterilization, the person has the right to appeal to a higher hereditary health court. If that appeal fails, or if the higher court declines to hear it, the sterilization is carried out. The law explicitly states the use of force is permissible. Now think about that process from the perspective of someone who receives a summons. You're a factory worker, a shop clerk, maybe a farmer. One day you get a notice to appear before a hereditary health court. You don't know why. You show up. Two doctors ask you questions. They review records you've never seen. They discuss your family history, your behavior, your intelligence. You have no lawyer. You can't challenge their medical conclusions. A week later, you receive a court order. You are to report to a clinic for sterilization. If you refuse, police will bring you by force. The system processes cases with industrial efficiency. In 1934, the first full year of operation, German hereditary health courts hear over 64 0-0 cases. By 1935, they're processing over 80 0-0 applications annually. The approval rate hovers around 90%. Think about what that means. Out of every 10 people summoned before these courts, 9 leave with a sterilization order. The courts aren't evaluating cases. They're confirming predetermined outcomes. Doctors file applications. Courts approve them. Clinics perform the procedures. The paperwork flows smoothly through every stage. Here's what the procedure looks like. A woman, let's call her Anna, receives her court order. She's been diagnosed with hereditary feeble-mindedness, a diagnosis so vague it could mean anything from actual cognitive disability to political nonconformity to simply being poor and uneducated. She reports to a state hospital. She's admitted to a surgical ward. The operation is performed under general anesthesia. For women, it's usually a tubal ligation. For men, a vasectomy. The surgery takes less than an hour. Recovery takes a few days. Anna is discharged with a stamp in her medical record marking her as sterilized. She can never have children. She never consented. She had no choice. And every step of what happened to her was legal, documented, and approved by a court. Multiply Anna's story by 350,000. That's the scale. Between 1934 and 1945, German doctors sterilized somewhere between 350, 0 and 400. 0 people under this law. Some estimates go higher. The exact number is hard to verify because not all records survived the war. But even using the most conservative estimates, we're talking about a population larger than cities like Florence, Iceland's entire population, nearly the size of New Orleans, all sterilized, all documented, all legal. And here's what makes this particularly insidious. The program doesn't look like an atrocity while it's happening. There are no mass graves, no gas chambers, no images that shock the conscience, just clinics, courts, and paperwork. Doctors go to work, judges issue rulings, nurses prepare operating rooms. Everyone follows procedure. Everyone can say they were just doing their job. The violence is administrative. The cruelty is bureaucratic. And that makes it almost invisible until you step back and see the full scope. Now here's the detail that changes everything. The Nazis documented everything. Every application included medical evaluations, family genealogies, intelligence assessments, photographs. Every court hearing generated transcripts. Every sterilization was recorded in hospital logs and patient files. Every appeal was documented with legal briefs and medical opinions. The regime created mountains of paper, all of it carefully filed, indexed and stored in government archives. Why? Because they believed this was legitimate public health policy. They thought history would vindicate them. They wanted a complete record to show future generations how they'd improved the German gene pool. That belief, that certainty that they were doing something scientifically sound and morally justified, created evidence that would survive the collapse of the regime. When Allied forces swept across Germany in 1945, they found warehouses full of documents. They found filing cabinets in abandoned government buildings. They found medical records in hospital basements. And they found a complete administrative history of systematic sterilization conducted on a scale no other nation had ever attempted. But we're getting ahead of ourselves. We need to understand who these defendants were before we see them in the courtroom. Because the men sitting in Nuremberg in 1946 weren't camp guards or SS executioners. They were the architects, the administrators, the doctors who made the system run. Let me introduce you to the key figures. Karl Brandt, Hitler's personal physician, and Reich Commissioner for Health and Sanitation. Brandt didn't perform sterilizations himself. He didn't need to. He signed policy directives that empowered thousands of other doctors to do it. He approved budgets for hereditary health courts. He reviewed statistical reports showing how many sterilizations were completed each quarter. His signature appears on documents authorizing the expansion of the program, the training of additional medical personnel, the construction of new facilities. Then there's Victor Brack, an SS officer who coordinated the administrative machinery. Brack's job was logistics, making sure courts had enough judges, clinics had enough beds, transportation systems could move patients efficiently. He treated human beings like inventory in a supply chain. His memos discuss processing capacity and throughput rates. He calculated how many sterilizations could be performed per clinic per month and worked to optimize those numbers. Several other defendants held senior positions in the Reich Health Office, the agency that supervised public health policy. They wrote the training manuals that taught doctors how to diagnose hereditary conditions. They designed the forms doctors filled out. They established quality control procedures to ensure sterilizations were performed according to standard protocols. These weren't sadists, they were bureaucrats. And that's exactly what made them so effective. Now, November 1945. Allied prosecutors are preparing for the main Nuremberg trial of top Nazi leadership. As they review captured documents, they realize they have a problem. The evidence of medical crimes is overwhelming, but it doesn't fit neatly into the charges against Goering, Speer, and the other major defendants. Medical experiments, euthanasia programs, forced sterilization. These crimes require specialized legal arguments. They need their own trial. By mid-1946, American authorities decide to pursue a series of subsequent proceedings focused on specific categories of crimes. The first will be the doctor's trial. Chief Prosecutor Brigadier General Telford Taylor assembles his team. They face a strategic question. How do you prosecute doctors for following the law? The sterilization program was legal under German law from 1933 forward. The courts that ordered sterilizations were legitimate judicial bodies. The doctors who performed the procedures had licenses, training, institutional backing. If the defense argues, we were following domestic law, how do you counter that? Taylor's answer is to argue that certain acts are crimes, regardless of domestic law. That there are fundamental principles of humanity that transcend national legislation. That forcibly sterilizing hundreds of thousands of people violates those principles so profoundly that it becomes a crime against humanity. A new category of international law being developed specifically for these trials, but making that argument stick requires evidence. Not just evidence that sterilizations happened, everyone knows they happened. Evidence showing the systematic nature, the scale, the calculated bureaucratic efficiency that turned a legal framework into a machine of violation. This is where the paper trail becomes crucial. Prosecutors don't need to find bodies. They don't need forensic evidence. They have something better. The regime's own records, files showing exactly how many people were sterilized each year, court transcripts showing how health courts reached their decisions, medical evaluations revealing the absurdly broad criteria doctors used, budget documents showing how much the government spent on the program, training materials showing how the Reich Health Office standardized procedures across hundreds of clinics. The prosecution team spends months organizing this evidence. They select representative cases that illustrate different aspects of the program. A woman sterilized for feeble-mindedness based on a 10-minute examination. A man sterilized for hereditary alcoholism because he was arrested drunk twice. A 14-year-old girl sterilized because her parents were poor, and a social worker decided poverty indicated genetic inferiority. Each case has a complete file, application, medical evaluation, court order, hospital record, all perfectly documented. And here's the prosecutorial strategy. They're going to present these cases not as isolated incidents, but as products of a system. They're going to show that the defendants created, managed, and perpetuated that system with full knowledge of what it did. That the bureaucracy wasn't a shield protecting them from moral responsibility. It was a weapon they deliberately constructed. December 9th, 1946. The doctor's trial officially begins. The courtroom is packed with international observers, journalists, legal experts. The defendants sit in rows looking more like a medical conference panel than accused war criminals. Judge Walter Beals presides over a 3-judge American military tribunal. Brigadier General Taylor stands to deliver the opening statement. Taylor doesn't start with sterilization. He starts with experiments. Dachau hypothermia tests, high-altitude experiments, infectious disease studies. He establishes the prosecution's framework. These defendants perverted medicine, turned healing into harm, violated the most basic ethical obligations of their profession. The courtroom listens to descriptions of experiments that killed hundreds. Defense attorneys take notes, preparing counter-arguments. Then, about 40 minutes into his opening, Taylor shifts gears. But the experiments were not the defendants' only crimes, he says. He explains that the tribunal will also hear evidence about the mass sterilization program. He outlines the 1933 law, the hereditary health courts, the systematic process that sterilized hundreds of thousands. And then he makes a critical legal argument. He states that even though these sterilizations were conducted under German law, they constitute crimes against humanity because they were performed without consent, targeted specific populations for elimination, and were executed on such a massive scale that they amount to persecution. The defense attorneys immediately recognize the problem. If the prosecution can establish that following domestic law isn't a defense, every argument they've prepared collapses. Defense attorney Dr. Robert Servatius rises during a recess and tells reporters the prosecution is trying to create ex post facto law, criminalizing acts that were legal when committed. He argues this violates fundamental principles of justice. Prosecutors counter that crimes against humanity existed even if they weren't codified, that certain acts are inherently criminal regardless of what any government declares. Over the following weeks, the trial becomes a battle over documentation. Prosecutors introduce exhibit after exhibit. Exhibit 426. Statistical reports from the Reich Health Office showing 375 zero sterilizations performed between 1934 and 1943. Exhibit 427, a memo from Karl Brandt approving expansion of the hereditary health court system. Exhibit 428, training materials teaching doctors how to identify hereditary feeble-mindedness. Exhibit 429, budget allocations for sterilization operations. The documents pile up, literally. Stacks of files accumulate on the prosecution table. Defense attorneys object repeatedly. They argue these are administrative documents, routine government records that don't prove criminal intent. They claim the defendants were implementing legitimate public health policy. They point to similar eugenics programs in other countries, including the United States, which had sterilized over 60,000 people under its own eugenics laws. If America sterilized tens of thousands, they argue, how can Germany's program be a crime against humanity? The prosecution's response is devastating. Yes, other countries had eugenics programs, but no other country operated on this scale, with this efficiency, with this complete disregard for individual rights. American sterilization laws, however ethically questionable, typically required some form of legal proceeding where the individual had representation. German hereditary health courts offered no such protection. More importantly, American prosecutors argue the scale and systematic nature of the German program transformed it from misguided policy into persecution. 350,000 people, processed through courts with 90% approval rates, forced to undergo surgery with police enforcement. That's not public health. That's systematic violation. Then prosecutors call their first witness on sterilization, Dr. Franz Blaha, a Czech physician imprisoned at Dachau who was forced to assist in camp medical operations. Blaha's testimony earlier in the trial focused on experiments. Now prosecutors ask him about sterilization procedures performed at the camp. Blaha testifies that he witnessed dozens of sterilizations performed on prisoners, often without even the pretense of a court order. He describes watching doctors perform the operations with clinical detachment, treating patients like specimens. His testimony establishes that even within the legal framework of the 1933 law, doctors in camps were sterilizing people arbitrarily, using the law as cover for unchecked medical authority. But the prosecution knows Blaha's testimony alone isn't enough. Camp sterilizations, however horrific, might be dismissed as aberrations, crimes by individual doctors exceeding their authority. What prosecutors need is testimony showing that senior officials, the men sitting in the dock, knew about the scale of the program and actively perpetuated it. They need documents with signatures. They need memos showing policy decisions. They need evidence that the machine was intentionally built and carefully maintained. In late January 1947, prosecutors introduce a series of exhibits that change the trial's emotional temperature. These aren't statistical reports or policy memos. These are individual case files, actual applications, court orders, and medical records from people who were sterilized. Let me walk you through one of them. Exhibit 512, the case of Margaret K. Moore, age 22, sterilized in 1936. Her file contains an application filed by a social worker who visited Margarita's family and concluded they lived in conditions of moral and intellectual inferiority. The social worker noted that Margaret had difficulty reading and seemed slow. No medical examination, no formal testing, just a social worker's impression. The application went to a hereditary health court in Munich. 2 doctors examined Margaret for approximately 15 minutes. They asked her basic arithmetic questions. She answered some incorrectly. They diagnosed her with hereditary feeble-mindedness. The court issued a sterilization order 3 days later. Margareta appealed. The higher hereditary health court rejected her appeal without a hearing. 2 months later, she was sterilized at a state hospital. The entire process, from initial application to surgery, took 4 months. Every step is documented in her file. The prosecutor reads this file aloud in court. The courtroom is silent. Then he stacks it on the table with dozens of others. This is one case, he says. We have hundreds more just like it, each one a person. Each one a life permanently altered, each one processed through a system the defendants designed and supervised. Defense attorneys try to argue that individual cases prove nothing about the defendant's culpability. These were decisions made by local courts, by individual doctors. The defendants didn't personally order these specific sterilizations. They were senior administrators setting policy, not making individual medical judgments. This argument might work in a different legal context, but prosecutors have prepared for it. They introduce a memo written by Karl Brandt in 1935, addressing complaints from some doctors about the broad application of sterilization criteria. In the memo, Brandt acknowledges that courts are interpreting feeble-mindedness very broadly. He acknowledges that some people are being sterilized based on minimal evidence, and then he writes that this is acceptable because the goal is to prevent as many genetically inferior births as possible, even if it means some individuals are sterilized unnecessarily. Better to sterilize too many, Brandt's memo suggests, than to risk allowing defective genes to propagate. The judges lean forward. This is the smoking gun. This is evidence showing that senior officials knew the system was being applied overly broadly and decided that was acceptable. The defense attorneys go pale because that memo destroys their argument that defendants didn't know what was happening on the ground. It shows they knew exactly what was happening and chose to let it continue. Prosecutors press the advantage. They introduce more documents showing coordination between the Reich Health Office and hereditary health courts, memos discussing how to streamline the application process, reports celebrating increases in sterilization numbers, training materials teaching doctors to interpret criteria broadly to capture more people. Every document reinforces the same point. This was a system designed to sterilize as many people as possible, operating under a legal framework that provided the appearance of due process while ensuring minimal protection for individuals. Then comes testimony from a survivor. Her name is withheld in court transcripts, referred to only as Witness H. She's a German woman, now in her 40s, who was sterilized in 1935 at age 16. Prosecutors call her to the stand. She testifies calmly, clearly. She describes being summoned to a hereditary health court. She was told she had hereditary epilepsy. She'd had 2 seizures as a child, both related to high fevers from illness. No seizures since age 12. It didn't matter. The court ordered sterilization. She describes the operation, the recovery, the lifelong knowledge that she could never have children. She describes the emotional toll, the sense of violation, the awareness that the state had taken something fundamental from her. Defense attorneys declined to cross-examine. What could they ask? The facts aren't in dispute. She was sterilized. It was legal under German law. Their only defense is that the law itself was legitimate, and her testimony makes that argument morally untenable. Over the following days, prosecutors established the full scope. They show that sterilization wasn't limited to German citizens. People in occupied territories were also sterilized. Poles, Czechs, Ukrainians, anyone the regime deemed genetically undesirable. They show that the program continued throughout the war, even as resources became scarce. Even as hospitals struggled to treat wounded soldiers, the sterilization program continued operating. Courts kept processing cases, doctors kept performing operations, the machinery didn't stop, and then prosecutors make their final argument about sterilization. They acknowledge that Germany wasn't the only country with eugenics laws. They acknowledge that sterilization, in some limited context with genuine consent, might be defensible medical practice. But they argue that what Germany created was fundamentally different. It was persecution disguised as medicine. It was the systematic elimination of reproductive capacity from populations deemed inferior by racial and genetic pseudoscience. And it was executed with such scale and efficiency that it became a crime against humanity, regardless of what German domestic law claimed. By March 1947, the defense is desperate. Their strategy of arguing legality has failed. The prosecution has shown that following the law isn't a defense when the law itself violates fundamental human rights. So defense attorneys try a different approach. They argue necessity and proportionality. They claim that Germany faced a genuine public health crisis, rising rates of mental illness, genetic disorders, social dependency. They argue the sterilization program was a harsh but necessary response to prevent societal collapse. Prosecutors demolish this argument in cross-examination. They bring in medical experts who testify that the hereditary nature of most conditions listed in the 1933 law was scientifically questionable even by 1930s standards. Schizophrenia's genetic basis was poorly understood. Hereditary feeble-mindedness wasn't even a legitimate medical diagnosis. Alcoholism isn't hereditary. The entire scientific premise of the program was flawed. And even if the science had been sound, even if these conditions were purely hereditary, the experts testify mass sterilization would be an ethically indefensible response. Genetic counseling, voluntary family planning, social support systems, all of these were viable alternatives that respected individual autonomy. The defense tries one more angle. They argue that the defendants were mid-level bureaucrats following policy set by higher authority. They point to Hitler, to Himmler, to senior Nazi leadership who established the ideological framework for racial hygiene. The defendants, they claim, were merely implementing policy they didn't create. This is the following order's defense in a different form, and it fails for the same reason. The evidence shows these defendants weren't passive implementers. They were enthusiastic architects. Karl Brandt didn't just follow orders. He expanded the program, increased its efficiency, celebrated its results. Victor Brack didn't reluctantly coordinate logistics. He optimized the system to process more people faster. These men built the machine. They can't claim they were just cogs in it. As the trial moves toward conclusion, prosecutors present their final piece of evidence on sterilization. It's a statistical chart compiled from Reich Health Office records. The chart shows sterilization numbers by year. 1934, 62, 463 sterilizations. 1935, 73, 194. 1936, 63, 547. 1937, 70, 886. The numbers continue through the war years, declining slightly as resources tighten but never stopping. The total, based on available records, approximately 375 Zur-Osro forced sterilizations between 1934 and 1945. Prosecutors let that number sit in silence for a moment. Then they say, each number is a person, a life altered, a choice stolen, and every one of these procedures was documented, approved, and carried out by the system these defendants created and maintained. The judges adjourn to deliberate. They face an unprecedented task. They must decide not just whether defendants are guilty, but what legal principles govern medical crimes committed under state authority. They must establish whether domestic law provides immunity for crimes against humanity. They must determine whether doctors bear special responsibility when they use medical authority to violate rather than protect. The deliberations take months. The judges review thousands of pages of evidence. They consult international law experts. They draft a detailed written judgment because they know this verdict will set precedent for decades. In their chambers, they discuss the sterilization evidence separately from the experiment evidence. The experiments were clearly murder, deliberate killings disguised as research, but sterilization is more complex. The victims survived. The procedures were legal under German law, yet the judges recognize that legalizing systematic violation doesn't make it less criminal. It makes it more dangerous because it gives perpetrators the cover of legitimacy. August 19th, 1947, the tribunal reconvenes to announce its verdict. The courtroom is packed. The defendants sit rigid in their seats. Judge Walter Beals begins reading the judgment. It's over 300 pages. He summarizes key sections. The judgment addresses sterilization explicitly. It states that the forced sterilization program, while conducted under German law, constituted crimes against humanity because it was systematic persecution based on race and genetics, conducted without consent, executed on a massive scale, and designed to eliminate specific populations from reproductive capacity. The judgment specifically rejects the defense's arguments. It states that domestic law cannot legitimize crimes against humanity, that following orders is not a defense when the orders themselves violate fundamental human rights, that medical professionals bear special responsibility because their authority makes violations more harmful and harder to resist. The judges write that doctors who use medical knowledge to harm rather than heal violate a trust so fundamental that their crimes carry heightened moral culpability. Then comes sentencing. 7 defendants are sentenced to death by hanging. Karl Brandt is among them. The judgment specifically cites his role in expanding and perpetuating the sterilization program as evidence of his criminal intent. Several defendants receive life imprisonment. Others get prison terms, ranging from 10 to 20 years. The sentences reflect not just what defendants did, but their level of authority, their enthusiasm, their knowledge of the harm they caused. But the tribunal does something else, something that transcends this specific trial. In an appendix to the judgment, the judges issue what becomes known as the Nuremberg Code, 10 principles governing medical research on human subjects. The first principle: the voluntary consent of the human subject is absolutely essential. Not preferred, not ideal when possible, absolutely essential, always. No exceptions. The code explicitly states that no state authority, no military necessity, no potential scientific benefit can override the requirement for consent. This is the legacy of Nuremberg. Not just the convictions, not just the executions, but the establishment of a legal and ethical framework that says medicine requires consent, period. The sterilization program violated that principle systematically. The 375,000 people sterilized never consented. Many never even understood what was happening until it was done. The hereditary health courts weren't protecting their rights. They were legitimizing the violation of those rights. And the doctors who performed these operations, who filed the applications, who signed the court orders, weren't practicing medicine. They were committing crimes. June 2nd, 1948. Landsberg Prison, Bavaria. 7 condemned men are executed by hanging. Karl Brandt is among them. His last words reportedly expressed no remorse. He claims he acted to protect German public health, that future generations will understand his actions were necessary. History has not been generous to that prediction. Brandt is remembered not as a public health pioneer, but as a war criminal who perverted medicine into an instrument of persecution. But here's what you need to understand about why this matters today, why a sterilization program that ended in 1945 and was prosecuted in 1947 still shapes every interaction you have with medical systems. The Nuremberg Code becomes the foundation for all modern medical ethics. When you sign a consent form before surgery, that requirement exists because of Nuremberg. When researchers must obtain informed consent before including you in a study, that principle comes from Nuremberg. When institutional review boards evaluate whether research protocols adequately protect subjects, that oversight system exists because the tribunal recognized that medical professionals can't be trusted to police themselves. New content begins here, 500 words. Think about what that means in practical terms. Every hospital in the developed world now has ethics committees that review treatment decisions involving vulnerable patients. Those committees exist because of Nuremberg. Every pharmaceutical company testing a new drug must prove they obtained genuine informed consent from trial participants before regulatory agencies will even review their application. That requirement is Nuremberg's direct legacy. Every medical school in America, Europe, and beyond now includes mandatory courses on medical ethics with case studies built around the doctor's trial. Future physicians learn about the 375,000 sterilizations before they learn advanced surgical techniques. The impact goes deeper than paperwork and procedures. The Nuremberg Tribunal established something unprecedented, the idea that professional ethics can override state authority. Before 1947, most legal systems assumed that professionals working within government authority were protected from prosecution. If the state ordered it, if the law permitted it, you were legally safe. Nuremberg shattered that assumption. The tribunal held that certain professional obligations, particularly in medicine, create duties that transcend national boundaries, domestic law, and state commands. This principle has been tested repeatedly since 1947. In the 1960s, when the Tuskegee syphilis study was finally exposed, investigators who allowed hundreds of black men to go untreated for decades claimed they were following approved protocols. The public and legal response invoked Nuremberg. Approved protocols don't excuse systematic harm. In the 1990s, when medical experimentation on prisoners and institutionalized people came to light across multiple countries, the Nuremberg Code was cited to establish that consent from captive populations is inherently compromised. In the 2000s, when pharmaceutical companies were caught conducting trials in developing nations without adequate consent procedures, international pressure forced reform by explicitly referencing the principles established in 1947. But the questions Nuremberg raised aren't settled. They remain urgent, contested, and relevant every time medical authority intersects with state power. Consider mandatory vaccination policies. Where's the line between legitimate public health protection and the forced medical intervention Nuremberg condemned? Consider genetic screening programs that identify hereditary conditions. When does identifying risk become categorizing people as genetically inferior? Consider criminal justice systems that mandate medical treatment as a condition of parole or probation. Is consent genuine when the alternative is imprisonment? These aren't hypothetical questions. They're active debates in courts, legislatures, and medical institutions worldwide, and every debate returns to the principle established by judges reviewing files from hereditary health courts. Medical intervention without genuine consent violates a fundamental human right that no public benefit can override. That doesn't mean these questions have easy answers. It means we have a framework for asking them, a baseline principle that any policy must satisfy. The 375,000 people sterilized under court order established that baseline with their suffering. New content ends, resuming original text. The Declaration of Helsinki, adopted by the World Medical Association in 1964, explicitly builds on the Nuremberg Code. The Belmont Report, which governs American medical research ethics, cites Nuremberg as foundational. Every major framework of medical ethics developed since 1947 traces its lineage to the principles articulated by those judges reviewing evidence of 375,000 forced sterilizations. And the principle is simple, powerful, and absolute. Your body belongs to you. No doctor, regardless of qualifications, regardless of institutional authority, regardless of potential benefits to society, can perform medical procedures on your body without your informed voluntary consent. Not for research, not for public health, not for genetic improvement, not ever. That principle seems obvious now. In 1947, it had to be established by a war crimes tribunal reviewing evidence of systematic medical atrocities. Let me bring this full circle to where we started. December 9th, 1946. 23 defendants facing American judges. 350,000 case files representing lives permanently altered. And a question, can following the law be criminal? The Nuremberg Tribunal answered yes. When law violates fundamental human rights on a systematic scale, following that law becomes participation in crimes against humanity. The doctors who sterilized hundreds of thousands of Germans under court order committed crimes, not because they broke German law, but because they enforced a law that itself was monstrous. That principle extends beyond medicine. It applies to any systematic state-sponsored violation disguised as legal policy. It says that bureaucrats can't hide behind legality, that professionals can't escape responsibility by citing regulations, that I was following the law is not a defense when the law itself is the weapon. The Nuremberg Tribunal established that individuals bear responsibility for the systems they create and perpetuate, regardless of legal frameworks that authorize those systems. So, here are the questions this history leaves us with. First, where's the line between legitimate public health policy and systematic violation? Every government regulates medical practice. Every health system makes decisions about resource allocation, treatment protocols, and medical standards. When does regulation become persecution? The Nuremberg Tribunal drew that line at consent. Any medical intervention without informed voluntary consent crosses into criminal territory, no matter what public health justification is offered. Second, what responsibility do professionals bear when state authority demands actions that violate ethical principles? The doctors at Nuremberg couldn't claim they were just following orders because their professional obligations transcended state authority. The tribunal held that medical ethics imposed duties that no government can override. That principle applies beyond medicine. Lawyers, engineers, scientists, any professional whose work affects human welfare bears responsibility for ensuring their expertise isn't weaponized, regardless of what legal frameworks permit. The 375,000 Germans sterilized between 1934 and 1945 cannot be unharmed. The damage is permanent, but the legal and ethical frameworks established at Nuremberg ensure that their violation wasn't meaningless. It became the basis for protections that every person in every developed nation now takes for granted. The next time you sign a medical consent form, you're benefiting from principles established by judges, reviewing files of forced sterilizations. The next time a researcher explains a study before asking your participation, that's Nuremberg's legacy. The next time an institutional review board rejects a research protocol as too risky, they're applying principles articulated in 1947. If you found this deep dive into primary source evidence and trial transcripts valuable, please subscribe. This channel exists to explore historical events using actual documentation, not simplified narratives. And I want to hear from you. Knowing what you now know about how the Nazi sterilization program operated under legal authority with medical legitimacy, what modern parallels concern you? Where do you see risks of systematic violation disguised as legitimate policy? Drop your thoughts in the comments. I read them all, and your perspectives help shape future content. The men executed at Landsberg prison in 1948 built a machine that destroyed hundreds of thousands of lives. They documented their work meticulously because they believed history would vindicate them. Instead, their documentation became the evidence that established principles protecting every person who walks into a hospital, participates in research, or encounters state authority backed by medical expertise. That's the legacy of Nuremberg, not just justice for past crimes, but protection against future ones.